back. Senate Bill 667. This is a joint between Consumer Protection and Health. This first measure is relating to health, requiring registration and regulation of practices of PBMs, authorizing periodic audits in pharmacies that submit claims to PBM companies. First, we're going to take testimony from Leanne Malapit.
Hi, good afternoon. I'm Leanne Malapit. I'm a community pharmacist on the island of Kauai, and I serve patients across the island, the central part of Kauai, and south and west. And this, I'm in support of this bill. It provides a lot of important points that is needed to cover PBMs in states. Currently, other states have PBM bills in place, and Hawaii just hasn't had any. We haven't gotten to that point yet. But I think it's something that's really important to regulate safe practices and to also bring down prices for patients and all of those important things. And the practice of pharmacy is one of the most highly regulated practices in the country. They say it's even more regulated than a nuclear power plant. And so we have everything regulated from the point of manufacture to distribution to the pharmacy to the endpoint user, the patient. Everything's carefully documented and done. With a PBM is a pharmacy benefit management company, and they manage the administration part of billing and clinical aspects about what's covered, what's not covered, and that kind of thing. So they actually are practicing they have an important role in determining patient outcomes, what's covered, how much is covered, day supplies that are allowed, etc. So with all of those things in place that they are responsible for delivering, they are right now completely unregulated in the state of Hawaii. They don't have to report or answer to anyone at this point. So it just assures safe practice in following standards that are coming across the other states as well, just to assure safe practices. There's some points about PBMs that I've seen as a community pharmacist that I've seen some areas that I think I'll just touch on from the patient's point of view, because that's really what we see. That PBMs in general and just bigger mail order companies, they always promote that there's a cost savings to the patient, but we actually see the contrary. We see a lot of negative financial impact on the patient, and one example is this situation called the Medicare Part D gap. And when patients hit the gap in their Medicare Part D plans, they actually have to pay out of pocket because they reach that certain dollar amount. And when they hit the gap, which is usually towards the end of the year, some people actually hit it earlier depending on how much their meds are costing. When they hit the gap, they have to pay the full price, whatever the PBM decides the price would be. When we send the claim through on the computer, it comes back with this price. It's usually way greater than what it would have been if it was being paid for under the insurance plan. So the patient is responsible for that whole price. The unfortunate thing that I've been seeing a lot of, which is really sad, there's a lot of elderly patients on Kauai in really rural areas with English as a second language, and they have a really hard time. So they come to me and they say, my end of the year medicines are so expensive and I have to do mail order. I don't have a choice because they're forced to by mandatory mail order. And in December, they're given a 3-month supply because they have to get 3 months at a time with mail order. So they have 3 months worth of meds in the gap, which is really unfortunate. So they pay this huge price. They get it in December. It lasts them through March. Then in February, they get an automatic refill for another 3 months. Now they have their deductible to pay. So they have another 3 months of really high copays because they have to meet their deductible now. So now they have 6 months of meds, essentially with this really high astronomical copay. So they really don't have the pharmacy benefit acting for them until July, which is it's really sad. If they came to an independent pharmacy when they were in the gap in December, we could have had the option to just bill for 1 month, get them through the gap till January when their new deductible would kick in, meet the deductible quickly rather than the whole 3 months just fill it for one, meet their deductible, then come the next fill, it would already be part of their insurance coverage. So there's a lot of there are negative impacts for the patient that aren't really cost savings, and that was just one scenario. And also when patients get filled for 3 months at a time, sometimes doctor discontinues the meds, and that's kind of a national study, a national survey that's been done, that studies do show that there is a huge amount of waste just from that one component alone, discontinued meds. And also, when they are restricted to get care from from only certain pharmacies or from mail order only, they have the patients have restricted access to pharmaceutical care, and a situation that I'll just tell you about was this just happened to me last week. A patient came to me and he was really upset because he couldn't get his medication for his blood pressure in time in the mail order. He had been waiting, and he had waited a week and it still hadn't come in. So he came to me because he used to come to us prior to being forced to go to mail order because it was mandatory for his plan. And so I tried to fill it, and it wouldn't go through because it said mandatory mail order. So I called the insurance company. I said, could I have an override because his meds didn't come in? And the insurance company denied covering it. They said he had to just wait for it to come in. So we had no recourse because they're not regulated by anybody. There was no one I could go to complain about it. And so he went, I just gave it to him at cost, plus I threw in, I paid for some of it just because he couldn't afford it. He then later told me thank you because it was his grocery money. So I felt so bad for him. But that's just one scenario, and I see that a lot.
Where they summarize me.
Okay. So the last part, there's another part of this legislation that talks about pharmacy audits, and what it does is that pharmacy audits should occur. They're just to keep pharmacies, compliant and honest, which is great. But I think they audit us too much. Sometimes they ask for the same prescription month after month after month, and I've already given it to them. And so there's no regulation in place for audits either, so it just wastes healthcare dollars and my payroll dollars. And they also recoup, they can extrapolate backwards and recoup anything that they want because there's no regulation. And they can also recoup for things that are just technical, like they didn't like how the patient's name was written because they couldn't really read it clearly, but we could read it because we know the doctor's handwriting. Stuff like that, they'll say no, not good enough, and they'll take the money back even though it was a legitimate script, patient got the meds and everything. So just we would appreciate having some regulation for this huge body that's now taking control over a lot of patient lives in the state. So we just would like to see better care given and more transparency to save money for everybody and to assure patient safety. Thank you.
Thank you very much.
You need to make sure that we have a copy of your testimony.
Jennifer Diesman, HMSA.
Sure, you stand on the testimony and position and eliminate your concerns.
Okay, thank you. Todd Inafuku, CBS.
Chair Green, Chair Baker, and members of the committee. I'll make this very short. My name is Todd Inafuku, testifying on behalf of CVS Caremark. We're in opposition to Senate Bill 667 relating to health. This measure imposes requirements that would stifle price and product competition and hurt all the plan sponsors. The plan sponsors are and it's the plan sponsors and really not the PBM that determine the plan design, the pharmacy benefit plan design.
So you're saying this is HMSA's fault?
No, we're contracted by HMSA to administer that portion of the benefit.
Okay.
Thank you.
Thank you very much, Todd. William Gu. In opposition, Javier Mendez Alvarez. In support. Other testifiers? Please. Thank you. Anyone else?
I apologize.
Sorry about that. How are you, Commissioner?
Good afternoon, Chair Green, Chair Baker, members of the committee. Gordon Ito testifying on behalf of the DCCA. The department opposes the bill. And the reasons for our opposition is one, and excuse for my ignorance in terms of pharmacy benefit management. I mean, the insurance division is charged with regulating insurance companies, and so if it's a risk-bearing entity, then perhaps we should be regulating PBN. However, if they're not risk-bearing entity, our jurisdiction is to regulate insurers, and generally the insurance division does not get involved with contractual relationship between insurers, and my understanding, I think what I view PBM is a contractual provider. And so we don't get involved with contracts. What we do, and our responsibility on behalf of consumers, is if there's a violation by the insurer of plan benefits, then that's when we get involved and enforce that violation of promised plan benefits. And so we feel it's outside of our jurisdiction. Also, we don't have the expertise to do audits on pharmacies, and some of the violations elicited in Section 7 of the bill, definitely we don't have any expertise to determine whether there's a violation or not. So that is our position. Thank you.
I appreciate it. Who would you recommend if we were going to do registration? Which department, if that was the process?
They're going to shoot me, but if it's merely registration, I would say professional vocational licensing is perhaps one area that does registration.
Yeah, I'm just surprised that the Board of Pharmacy is not here.
Yeah, and so if it's
because I
merely
think there are some regulations on PBMs, but not in the way that the testifier from Kauai was interested in.
Okay, thank you, Gordon. Others testify, please.
Thank you, Chair. I'll be brief. I'm here on behalf of Hawaii Food Industry Association, and this is actually an issue we've become increasingly more concerned about just due to the evaporation of market share for pretty much everybody besides CVS Caremark due to some recent changes. And we just wanted to point out that almost 80% of the population is served by this one PBM, and it's not necessarily a good thing to have that complete lack of competition. And this bill really just kind of ensures that there are some basic safeguards requiring them to be registered with the insurance commissioner, making them accountable to Hawaii's residents, and seeking that they report to the commissioner yearly about many different things. And our testimony kind of outlines some of our other concerns. But thank you very much.
Thank you very much.
Mr. Chair and Member, Cindy Laubacher, Senior Director of State Affairs for Express Scripts. I've submitted testimony and I'll stand on that. I just wanted to clarify a couple of points raised by the pharmacist earlier. To Senator Baker's point, we are regulated. Our mail service business is regulated by the Board of Pharmacy. So we are regulated and we are licensed as a non-resident pharmacy, and therefore we're regulated. All of our mail service business is in fact regulated by the Board of Pharmacy. To the issue of mandatory mail, in the example given, that's about Part D. Part D prohibits, in fact, mandatory mail. So there is no mandatory mail in Medicare Part D because it's prohibited by federal law. Mandatory mail, however, is a tool available to our plan sponsor clients, whether health plans, trusts, union trusts. It's rarely used, but it is out there. I'm not aware that we have any contracts within the state that have mandatory mail in them. I can go back and look at that, but that is a decision used by our clients. They tell us if they want mandatory mail. It's not. We offer it, but again, very rare that it's utilized.
You mean
the health plan, the employer, the union trust, whoever our client is.
They ask for that. If it's, you can do it if they ask.
Correct, but it's pretty rare because, for the reasons stated, most patients don't like it. So
I believe we have it for EUTF.
Do you?
Yes.
I don't have that contract, so I know it's out there. I just don't know to what extent it's out there. But for Express Scripts, it's a very small part of our business, and I don't know of any clients within the state that have it for us. So I just wanted to clarify that one point. Thank you.
Thank you very much. Any questions, members? Okay. Why don't we move on to our next measure? This next measure, we have already addressed some of these concerns. I'm going to defer to the chair here in a moment. This is Senate Bill 1241, asking for an amendment to exclude from unfair competition antitrust laws certain discussions between healthcare providers and facilities, plans, government agencies, or healthcare-related organizations. And we did discuss this. Did you want to make a comment before?
Yes, I want to have some additional discussion on this topic because I think they're based on Mr. Kimura's concerns and his discussion that we had on the previous bill I think there may be a workaround on that. So if Beth Geesting could come forward and present some testimony. The issue that we were discussing, and the reason I want it on the record, because then if you want to amend the other bill and use that one as opposed to this one,
Whichever.
either way, there may be an opportunity to address this in a way that might work for the Attorney General. And that is that if we were to create some kind of a commission, so can you share with the committee what some of your thoughts are with regard to how we might address the state oversight aspects to allow these kinds of discussions and why the discussions are important?
We believe that having discussions with the payers and providers is very important in terms of standardizing and doing administrative simplification, a number of other aspects of healthcare transformation that we're working on. I, of course, rely on the Attorney General for the best legal advice, and as I understand it, and of course he's sitting right here, so he can correct me if I have any of this wrong. The important thing is that the state clearly define the purpose, identify the process, and that a state authority be overseeing and convening this group. So the workaround, I believe, would be for us to put our heads together and figure out who the most appropriate state authority would be to make this a possibility so that we can continue to work on these things and make sure that we are not going to be violating anything.
The state currently has on the books a Hawaii Health Authority.
Yes, ma'am.
It clearly is not defined in this fashion, but I think with some tweaks to what it does and maybe some additional members and creating a commissioner, which might be the governor's health coordinator, that might be an entity that could be utilized to facilitate the discussions and frame the issues, particularly in the area of health transformation. Would that be something that you think you would be amenable to if the committee were to decide to go in that direction?
I think that would be a strategy that is well worth considering, because that body already exists, and because of the Affordable Care Act, some of the responsibilities that were assigned to the health authority probably need to be re-examined. So identifying some different purposes and kind of reshaping it, I think, would be positive.
If the committees were so inclined, or the health committee, because there's another bill, and I defer to chair whichever one he wants to use.
This one's better because we got you and Judd, so we had a little extra crack at it. Yeah.
What I was going to suggest is that if we put all of our collective heads together and sent this over to Judiciary, but maybe got back for decision making on the 13th. Or the 12th or the 13th, then we might have something that we could take a look at and try to use that as a vehicle to address. And then this would be amendments to this bill, but then it would go forward to Judiciary, and we could have a more thorough discussion. And maybe even after the initial discussion, if we shop the draft around enough, that we could have a robust discussion before decision making.
Give you a lot more time to work with the health authority.
Thank you.
You're welcome.
So, what's today? Today's
6th.
Today's Wednesday. Do you think wouldn't be a real gut replay, so we wouldn't have to do another hearing at this level, I wouldn't think.
No, we could just amend this to have the agency that it was put under be the healthcare authority with supervision from the governors.
We have to do some amendments to the authority, but maybe you could. Do you think if we do you have a hearing? What's your hearing schedule next week?
Wednesday with you, very likely.
Okay, why don't if we got something before next week Wednesday, so we can have it for decision making and discussion Would that give you sufficient time to work with Mr. Kimura and any of the other folks that could give us at least a framework? Doesn't have to be all fleshed out, but a framework that we could send over to Judiciary for their, additional consideration.
Yes, I think we can do that.
As we continue to work on it.
Good. Excellent. Okay, so we also had testimony, thank you, Beth, from the Attorney General's office.
Sure. Well, you've heard my testimony the other day. The only add-on was because this bill's description specifically mentioned the intent to exclude these collaboration from the unfair competition law. We added some language discussing that. That we get it. We understand the collaborations are good. This provides opportunities for great advancement in healthcare. However, there's also the potential for negative consequences because you have private sector people getting together by and large. And this is going to be a collaboration that's self-implemented, self-policing, and unsupervised by the state. That's putting aside what your plans are. So we felt that this, again, was a reason for this bill to be held because it will expose the participants to antitrust scrutiny because there's no active state supervision. Now, I just wanted the committee, the chairs, to understand that I'm not here to say we oppose collaborations. We understand there's good. And in fact, DOJ does too. There's a whole handbook that's put out there on product marketing research collaborations. The problem is that when the private sector gets together, there is a perception on the part of the Supreme Court that they're getting together to further their interests as opposed to the interests of the government. And so the Supreme Court has said the state may not confer antitrust immunity on private persons by fiat. And that's really what this bill does right now. The mere presence of the state is not enough. Even our participation is not enough. We have to be the active decision maker at the very tail end saying this is good so that the product of the deliberations and decision making is that of the government and nobody else.
Mr. Kimura, can I give you a scenario and see if that might help you to help us frame what we need to do?
Sure.
The state of Hawaii, as I understand it, is asking for a very large planning grant that furthers our health transformation agenda from the federal government. And part of that that the feds are requiring is this kind of collaboration. Mm-hmm. So we actually need to have a framework established so that we can actually do that collaboration so that we can fulfill the requirements of the grant, but at the same time help to move us with all of the partners that will come to the table to make sure that we can get some things happening in healthcare transformation. So it's actually very timely that we have this conversation because there is a real need and a concrete need to do this. So with that sort of in background, could you help us sort of frame something that you think would both further the objectives of the healthcare transformation agenda, but also enable people to participate with active state oversight?
I think we can try and do something about that. Now, let me step back a bit.
Okay.
As one of the things I said the other day, there is no need for the immunity. If the four of us were talking, pristine and pure, did nothing wrong, you're not going to see the state coming after you. You're not going to see the feds coming after you. The only sector that might come after you, perhaps, is if there's a disgruntled, non-participant private sector person saying, hey, you excluded me or you're biased against me, and so that's your exposure level. But again, if you're not done anything wrong, then you shouldn't have to worry about that. So it only comes about because there's the concern expressed by the community. So there's nothing to stop the collaborations from occurring now under that scenario.
Okay. Thank you. Thank you, Adrian.
Okay.
No cold water, Mr. Grandy.
Well, there's been lots of groups that have been represented. The only groups that's not represented are the consumers. And as drafted, this bill is anti-consumer and anti-business. Now, I understand that the committees are looking in a different direction, and I would certainly defer to the Attorney General as to what's appropriate and what's not appropriate. But I think the distinction, and I don't mean to put words in the Attorney General's mouth, but the question is this going to be a state entity that's making decisions on behalf of the state, which I don't think I would have any objection to, provided that there is full participation, including participation by consumers, versus allowing all the private groups to get together to the exclusion of consumers to make decisions on their own. And I think the bill that the committees are talking about is significantly different than the bills that I mentioned. I do want to mention one final thing, because I think it's something that no one is focusing on, and I'll say it again. Our Consumer Protection Bill regulates antitrust, unfair competition, and unfair and deceptive acts and practices. And as drafted, this allows all three of those causes of action not to be brought against any healthcare provider. As you're trying to regulate PBMs, the bill as drafted basically allows them to get away from and get out of any liability under our unfair and deceptive acts and practices and unfair competition law. So I have no objection to the revised intent of the bill, provided that at the end of the day it's the state making the decisions and not, no disrespect intended, the for-profit, self-interested healthcare providers and insurance companies. Thank you.
Thank you very much. HMSA?
Stand on the testimony in support of, it actually refers to the process that just occurred with Ms. Easton.
Okay, thank you. Healthcare Association.
Good to see you too, Chair Baker, Chair Green, Senator John Oakland. I'm George Green, President and CEO of the Healthcare Association of Hawaii. We have submitted testimony, and I've actually had conversations today with Beth Giesting and the Attorney General, and we are very supportive of continuing the dialogue. I think having their input and guidance, specifically from the Attorney General, can lead us down a path to some legislation that can really support the intent of what our members have asked us to do. So having had those conversations today, I'm very encouraged to continue that process and continue the dialogue. So we're in support of this measure continuing to move forward. Thank you.
Thank you, George. Anyone else wishing to testify on this matter? Why don't we take a brief recess?